Hello and welcome to another episode of Analyzing Mormonism. Today I'm going to be talking about the lawsuit. Let me pull it up here for a second. Oh, that's cool. The underlying lawsuit in the last episode that I shared about the church suing their insurance providers. So this is the civil action number 13C656. This is the entirety that I could find, and it's really long, so I'm going to see how far I can get into this. So I've never read it. I kind of know the gist of what it is because I was putting all these into slides, but I have not read it in detail. So that's what we're going to do today. I'm just going to go through all of this and put into context why the church or what happened with the church and suing their insurance providers. So this will be really interesting. Okay, so this is what the civil case is. It's Jane Doe. There's a whole bunch of different, I think it's 9 individuals who are in this case against the Church of Jesus Christ of Latter-day Saints. So syllabus by the court, excuse me. Number 1, in reviewing a circuit court certification under Rule 54B of the West Virginia Rules of Civil Procedure, this court applies a 2-pronged test. First, we scrutinize de novo the circuit court's evaluation of the interrelationships of the claims in order to decide whether the circuit court completely disposed of one or more claims, which is a prerequisite for an appeal under this rule. As to the second prong of the inquiry under the rule, whether there is any just reason for delay, this court accords the circuit court's determination considerably more deference than its first prong determination. The circuit court's assessment that there is no just reason for delay will not be disturbed unless the circuit court's conclusion was clearly unreasonable because the task of balancing the contending factors is peculiarly one for the trial judge, who can explore all the facets of a case. Number 2, where an appeal is probably obtained from an appeal decree either final or interlocutory. Such appeal will bring with it, for review, all preceding non-appealable decrees or orders, from which have arisen any of the errors complained of in the decree appealed from, no matter how long they have been rendered before the appeal was taken. 3, a civil conspiracy is a combination of 2 or more persons by concerted action to accomplish an unlawful purpose, or to accomplish some purpose, not in itself unlawful, by unlawful means. The cause of action is not created by the conspiracy, but by the wrongful acts done by the defendants to the injury of the plaintiff. 4, a civil conspiracy is a legal doctrine under which liability for a tort may be imposed on people who did not actually commit a tort themselves, but who shared a common plan for its commission with the actual perpetrators. The petitioners, plaintiffs below, are 9 minors and their parents, individually and as parents, guardians, and next friends, in this action alleging various negligence claims, fraud, intentional infliction, and emotional distress, assault, battery, and civil conspiracy related to, arising from, and resulting in defendant Michael Jensen's known and alleged sexual abuse of the minor plaintiffs. Following the extensive discovery, the Circuit Court entered an order on December 4, 2015, through which it granted summary judgment in favor of the respondent, defendant below, unidentified defendant 1, UD1, against whom conspiracy was the only claim asserted. On December 30, 2015, the Circuit Court entered the order granting several of the defendant's motions in limine, which eliminated a large portion of the plaintiff's circumstantial evidence in support of their conspiracy claim. The following day, December 31, 2015, the Circuit Court entered an order granting summary judgment on the plaintiff's conspiracy claim in favor of the respondents, defendants below, Corporation of the President of the Church of Jesus Christ of Latter-day Saints, Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints, Stephen Grow, and Don Fischel, collectively the church defendants, and in favor of the respondents, defendants below, Christopher Jensen and Sandra Lee Jensen. On January 11, 2016, the Circuit Court entered an order clarifying its interlocutory summary judgment rulings as final judgment pursuant to West Virginia Rule of Civil Procedure Rule 54B. In addition to seeking a reversal of the summary judgment orders, the plaintiffs asked this court to reverse those in limine rulings. They assert these rulings facilitated the Circuit Court's issuance of summary judgment rulings without first evaluating the evidence offered in support of their conspiracy claims under the strictures applicable to summary judgment. Upon our careful review of the parties' brief, the arguments of counsel, the appendix record submitted, and the applicable law, we reverse the summary judgments and in limine rulings and remand this action for further proceedings consistent with this opinion. Facts and procedural background. In late 2004, Chris and Sandra Lee Jensen, collectively the Jensen parents, and their children were residing in or near Provo, Utah. Their son, Michael Jensen, who was then 13 years old, was arrested at his middle school and charged with 2 felony counts of sexual abuse of a child. The incidents occurred in November and December of 2004, and his female victims were 12 and 13 years old, respectively. On both occasions, Michael waited for his victim to exit a classroom before pinning her against a wall and grabbing her buttocks and breasts without her consent. One of the victims indicated in her statement to the police that during Michael's attack upon her person, he told her that they needed to have sex, that she was really scared, and that she had kneed Michael in the groin to get away. The defendants minimized the severity of the incidents, describing them instead as brief groping of two female classmates over their clothes while at school. The plaintiffs alleged that a conspiracy began in Provo when the Church of Jesus Christ Latter-day Saints Church influenced Michael's criminal proceeding, which resulted in 2 felony charges being reduced to misdemeanor sexual offenses. Among other assertions, the plaintiffs state that Michael's paternal grandfather, Blaine P. Jensen, who has held very high positions within the church, attended a meeting between Michael and Michael's attorneys and was present for Michael's dispositional hearing in January of 2015. Dale Swenson, Michael's church bishop in Provo, also attended the dispositional hearing. During this hearing, the juvenile petition was read and reports were submitted, including a sexual behavior risk assessment, SBRA, which indicated that Michael's offenses are based primarily on opportunity and that he will offend if given the opportunity. The juvenile court then accepted Michael's admission to reduce charges of 2 misdemeanor counts of lewdness involving a child, placed him on probation, ordered his parents to comply with the terms of probation, and ordered him to complete 50 hours of community service and a sexual appropriateness class, with the family component with proof of completion to be provided to the court. The defendants allege the plaintiffs have no evidence the church influenced Michael's proceedings in any manner, and that affidavits and declarations from the prosecutors involved in Michael's juvenile proceeding refute the existence of any such influence. Although the defendants allege Blaine Jensen's involvement was simply that of a grandfather assisting his grandson, the plaintiffs point to evidence that Michael told his friend, JC, he had been in legal trouble in Utah and that his grandfather, quote, was in leadership position for the church and helped take care of whatever needed to be taken care of, unquote. The plaintiffs further allege that although the church knew that Michael had pled guilty to 2 sex offenses in Utah, it did nothing to warn or protect, despite the existence of an abuse prevention and response procedure, referred to as an annotation system. The defendants allege that their evidence demonstrates that the church rarely annotates its records for children, and even less so where the misconduct does not indicate a danger to much younger children. During the summer of 2005, the Jensen family moved to Martinsburg, West Virginia. Soon thereafter, Sandra Lee Jensen was asked to serve as the church's Relief Society president for her new ward, which she accepted. In that role, Mrs. Jensen reported directly to her ward bishop, who was at the time Matthew Whitcomb. She also oversaw the Sunday school for the women and was responsible for compassionate service for all ward members. Shortly thereafter, Chris Jensen was placed on the Stake High Council, which is an advisory body to the stake president, who at all relevant times was defendant Stephen Grow. In their effort to further demonstrate the defendant's knowledge and awareness of Michael's history as an abuser, the plaintiffs alleged that there was a Stake High Council meeting in 2006 or 2007, during which leaders of the Martinsburg stake discussed Michael Jensen's abuse of a younger sister and possibly another girl, and Chris Jensen's possible abuse of his son Michael. They further alleged that at the same time, stake president Grow asked UD1 to keep an eye on Chris Jensen, who was UD1's close friend, and to report back to him. UD1 indicated during a recorded interview that through his position on church councils, he was aware that church leaders had been working hard with Michael Jensen to get him the help that he needed in the 2007-2008 timeframe. The defendants denied that this 2006-2007 Stake High Council meeting ever took place, or that stake president Grow ever made such a monitoring arrangement with UD1. The plaintiffs alleged that April 2007, through her role as Relief Society president, Sandra Lee Jensen was arranging for Michael to babysit the children of ward families. Wow. They further allege that because there had been no disclosure concerning Michael's prior sex offenses in Utah by the Jensens or the church defendants, the plaintiff Doe 6 parents allowed their 4-year-old daughter, PC, to be babysat by Michael, who sexually and physically abused her by repeatedly laying down in her bed with her and making her touch his penis. The plaintiffs further alleged that when the Doe 6 parents returned home, PC was extremely upset, had a handprint-shaped bruise on her bottom, and was terrified of Michael. When Jane Doe 6 confronted the Jensen's parents, who were both church officers at the time, they explained that PC was upset because Michael had not fed the Doe 6 children properly. Sandra Lee Jensen assumed that Michael had spanked PC, and Chris Jensen believed that Michael needed more tutelage from his mother to become a better babysitter. Wow. Moving forward to June 2007, the plaintiffs alleged that Michael Jensen assaulted JM, a 14-year-old girl. JM testified that Michael invited her to go to the movies, telling her that there was a huge group of people from the church going. According to JM, after his mother dropped her off at the movie theater, Michael purchased her ticket, and as they walked through the door of the theater, he grabbed her, pulled her close, and started touching her breasts. She testified that he had pulled her out of the theater, pushed her up against a wall, and continued touching, kissing, and, quote, doing all this other stuff as she tried to press him back. Explaining further, she testified that Michael's older brother, Blaine, came out of the theater, yelled Michael's name, quote, dragged him, Michael, inside the theater, and therefore kept Michael away from her. She testified that she was upset, that Michael had made her feel as if she, quote, owed him something just because he paid for her ticket, unquote, and that she did not report the incident to the police because she was humiliated. She further recounted subsequent contact with Mrs. Jensen, who approached her and asked whether she was okay and, quote, do we have a problem, unquote. The plaintiffs alleged that Mrs. Jensen, quote, linked in her mind, unquote, the incident with JM to Michael's Provo sex offenses, which prompted her to confer with Bishop Whitcomb about the matters. Mrs. Jensen testified that the only link in her mind was her concern, as a religious woman, with Michael's premarital displays of sexuality, and that her conversation with Bishop Whitcomb was along these lines with only a passing reference to Michael's offenses in Utah. During the fall of 2007, the plaintiffs alleged that church leaders discussed Jane and John Doe 1's marital difficulties, and that Sandra Lee Jensen, as Relief Society president, offered Michael as a babysitter if the Doe 1 parents needed some time alone. Mrs. Jensen testified that she did not disclose Michael's sex offenses in Utah or the injury he had inflicted on PC to Jane Doe 1. The plaintiffs alleged Mrs. Jensen also failed to mention that Michael was no longer allowed to babysit his siblings, Michael's assault of JM, or her conclusion that he should not babysit unsupervised. Jane Doe 1 accepted Mrs. Jensen's offer of childcare, and Michael babysat JT, then aged 3, and WT, then aged 4. These children were later disclosed to their parents that the evening Michael babysat them, he blindfolded them, put ketchup on his penis, and forced them to perform oral sex on him. Criminal charges for these offenses were brought against Michael in 2012. He was tried, convicted, and sentenced to 35 to 75 years in the penitentiary, and he has been designated a violent sexual predator. I'm just going to take a second. That's really heavy. I feel really bad for these kids who had to go through all this. And it's not over. We have more cases. In early 2008, UD1's 2-year-old son, CP, was cared for in the Jensen home and came home with a swollen penis and abrasions on the inner part of his upper thighs. Neither UD1 nor his wife, SP, who was at that time a neonatal intensive care nurse, sought medical treatment for CP, which the plaintiffs allege was because they knew it was a result in mandatory reporting to state authorities. UD1 and his wife knew CP's injuries could not have been self-inflicted because of his physical disabilities. When interviewed by the plaintiff's counsel, UD1 stated that Sandra Lee suggested to his wife that CP's injuries might be diaper rash, which his wife, who was a nurse, knew it was not. UD1 also stated during this interview, as did FP, during her deposition, that CP, who had been potty trained thereafter, began wetting the bed again. The plaintiffs alleged that sometime between February through April of 2008, Jane Doe 2 approached Sandra Lee Jensen, who was still serving as Relief Society president, about her need for after-school care for her sons, 4-year-old ZW and 6-year-old AW. According to Mrs. Jensen's testimony, she proposed Michael to babysit the children in the Jensen home, indicating that she would be there as well. She did not disclose any information to Jane Doe 2 about Michael's prior offenses, as discussed above, or his fitness as a babysitter. Over the following weeks, the plaintiffs alleged that Michael forced ZW to perform oral sex on him and forced AW to watch. ZW testified that on one occasion, when he told Sandra Lee that Michael was abusing him, she said, "Okay," and just ignored it. In April 2000, ZW told his mother about the abuse. I'm sorry. This is really hard. Jane Doe 2 testified that she saw the fear in her son's eyes and never doubted his truthfulness about what had happened. She told Sandra Lee what Michael had done, and a day or two later, Michael and his father, Chris, appeared at her home, denying the abuse ever happened in an aggressive manner that caused her to feel intimidated. Wow. Jane Doe 2 further testified that she and her husband arranged a meeting with defendant Bishop Fischel, during which they disclosed Michael's sexual abuse of ZW, and Bishop Fischel indicated he would look into the matter. According to Jane Doe 2, when she saw Bishop Fischel at church, approximately 1 week later, he told her he had spoken to Michael. He did not believe that Michael had abused ZW, and that ZW might have been exposed to pornography. How old is ZW? The 6-year-old? Oh no, the 4-year-old. What the heck? Jane Doe, too, testified to a separate but similar conversation with Bishop Fischel. When Bishop Fischel was deposed, he denied ever speaking to Jane Doe, too, about Michael's alleged sexual abuse of her son, and asserted any conversation he had with Jane Doe, too, did not involve sexual abuse. Bishop Fischel's testimony reflects that a few weeks later, he selected Michael Jensen and his brother Blaine Jensen to be first and second assistant to the bishop, an honor within the church. Wow. So this Relief Society president is ignoring this. If I'm reading this correctly, this Relief Society president is ignoring what's happening. She just keeps recommending this kid. And then this bishop has just promoted this kid who has all these sexual abuse claims against him, and he knows it. Oh. The defendants allege that neither ZW's parents, quote, believed ZW's account enough to report the abuse to the authorities, unquote. And Jane Doe, too, never disclosed any abuse of her son by anybody. Conversely, Jane Doe, too, testified she and her husband considered reporting the abuse to authorities, but after speaking to Bishop Fischel, they decided that ZW had been through enough, that his allegation would be questioned, that there would be persons who would not believe him because it would have been ZW's word against Michael Jensen's denial, and that she did not want ZW to be ostracized. Again, I think this is this 4-year-old, right? 4-year-old ZW. Guys. By early 2009, Sandra Lee Jensen was no longer the Relief Society president, but had assumed oversight of the church's Cub Scout program. When Jane and John Doe 3 indicated their inability to attend her Cub Scout training one evening because someone would need to watch their younger children, Sandra Lee offered to have her children babysit the Doe 3 children. Jane Doe 3 testified that Michael and a Jensen daughter babysat her children in the Jensen home, including her 3-year-old son, C.H., who later disclosed Michael followed him into the bathroom, shut the door, and when he pulled on his pants to use the toilet, Michael touched his penis. Although the defendant states C.H. denied Michael ever abused him, the plaintiffs point to contrary evidence in the appendix record and to the circuit court's denial of the defendant's motion for summary judgment on the claims of C.H. and his parents. The record reflects that around the same time in 2009, Sandra Lee emailed her former bishop, Matt Whitcomb, expressing her concern that Michael posed a risk to her other children. She advised Mr. Whitcomb that she and her husband were trying to think of different options to help protect Michael from himself, and asking whether there were any farmers in the area who would be willing to take in Michael. She also expressed to Mr. Whitcomb her comfort in seeking his help because he knew some of the history. In early 2010, Chris Jensen found 18-year-old Michael in the bedroom of his 12-year-old sister, KJ, who was lying on her bed. Mr. Jensen testified that he had Michael leave the room, after which his daughter told him that Michael had lain on top of her and tried to kiss her. During her deposition, KJ described this incident as Michael first lying down beside her on the bed, then climbing on top of her, after which he kissed her for what seemed like 10 or 20 minutes, and possibly moving his pelvis against her. She stated that she was terrified. From that point forward, the Jensens banned Michael from their home, although he stayed in a tent in their backyard at various times. Wow. The Jensens met with Bishop Chris Vincent, who is a bishop in their stake, but was not their ward bishop, and reported Michael's abuse of KJ. Bishop Vincent testified that during this meeting, KJ told him about a court case in another state where Michael was tried for hitting a girl. Bishop Vincent testified that he told no one else within the church about his meeting with the Jensens, that he agreed to counsel Michael, that he did not ask Michael about his abuse of KJ, or his earlier case that she had referenced, and that he gave Michael keys to the church building so he would have a safe place to sleep. Wow. Between 2010 and June 2011, Michael sometimes lived with church families, including the Doe 4 family, who took him on a family trip to South Carolina. Jane Doe 4's son, JC, who was Michael's friend, testified the only concern he was aware of Mrs. Jensen expressing was her worry that Michael would mess up or hook up with a girl at the beach. Michael went on that trip, during which he allegedly abused the Doe 4's 8-year-old daughter, AB, touching her genitals over her clothing. Sandra Lee Jensen testified that she knew Michael was living with the Doe 4 family, but she did not disclose anything to them about Michael's history of abuse, including his recent abuse of his sister, KJ. As Sandra Lee explained, she did not feel any need to warn the Doe 4 parents because KJ was more developed than because KJ was more developed than the Doe 4's daughter, who was about the same age. So this family takes in her kid and she doesn't warn them anything that was going on. Like, oh, she's not as physically developed, so there's no need to warn her. That That is so foolish, and that means nothing. Like, that makes no difference. During the same time, the plaintiffs alleged that the church continued to hold Michael out as a trustworthy member of the community, and in early 2011, he was asked to serve as a substitute teacher in the church's primary program and taught a class of 4-year-old children. Oh my gosh. Wow. In June 2011, Michael was approved for a church mission, which UD1 indicated had been delayed while Bishop Fisher worked with Michael on his various issues. So all these bishops know about this boy and the troubles that he's in. But what do? They call him to be in charge of the 4-year-olds, and they say he can go on a mission. In January 2012, while Michael was on his mission, JT and WT disclosed to their parents, John and Jane Doe 1, that Michael had abused them 5 years earlier. Jane Doe 1 reported the abuse to the West Virginia State Police. Bishop Vincent informed President Grow about these allegations against Michael involving the Doe 1 children, including that he had called the church's helpline to advise church officials in Utah of the West Virginia State Police investigation, and that the state police wanted to interview Michael. Although the church brought Michael back to West Virginia early from his mission in Arizona, the plaintiffs alleged that the Jensens and church leaders met and agreed to not disclose his return to the police. The plaintiffs further allege Michael fabricated a story that he returned early from his mission due to a bicycle accident, and that Stake President Grow did nothing to correct the fabrication. Okay, wait, hang on. Let me see if I can understand this correctly. So they called the helpline. They're like, hey, there's this case going on in West Virginia. So what do we do? And so they send him home. They call him home early from his mission to Arizona. The Jensen leaders met and agreed to not disclose his return to the police. So the church sends him home, but they don't tell the police that he's home. Is that what I'm getting? The plaintiffs further allege Michael fabricated a story that he returned from his mission due to a bicycle accident. Hey, you guys, I'm home because I was in a bike wreck. The stake president, who knew why he was home, didn't correct this story at all. He just let everyone believe that he was not a sexual abuser. The Jensens state that Chris Jensen was deployed when Michael returned early from his mission. And because Mrs. Jensen did not want Michael living at home without his father there, Mr. Whitcomb, who was then a stake high counselor, agreed to let Michael live with him and his wife. Mr. Whitcomb testified that when his daughter and grandchildren planned a visit, he told Michael to find another place to live because there was not enough room in his home for everyone. Mr. Whitcomb asked John Doe 5 if Michael could live with his family. Although the John Doe 5s had young children, the plaintiffs alleged that neither Mr. Whitcomb nor any church official or defendant told the Doe 5s the reason for Michael's early return from his mission, or about Michael's history of sexual abuse. Mr. Whitcomb testified that he believed John Doe 5 was aware of the allegations against Michael, based on conversations he had with John Doe 5, but he could not specifically recall the dates of those conversations. Wow, so he says, hey, I can't take him, I can't take care of him, so you take care of him. And he doesn't tell them anything that's happening or has happened in the past. John Doe 5 testified that both Stake President Grow and Bishop Fischel encouraged him to allow Michael to live in his home. Michael Jensen lived with the John Doe 5s from May 2012 until August 2012. John and Jane Doe 5's son, MS, testified Stake President Grow told him that it was good that Michael was living with the Doe 5 family, that Michael was a good guy, and that he would be a good role model for MS. The plaintiffs alleged that during this time, Stake President Grow was counseling Michael on a regular basis. The plaintiffs further alleged that while Michael lived with the Doe 5 family, he touched the genitals of the Doe 5 boys, 6-year-old TS and 10-year-old MS, on several occasions. During therapy with a psychologist, TS described looking into the living room at his home on one occasion and seeing Michael holding his brother's head down to Jensen's crotch and humping his brother MS's face. He drew a picture of what he had observed. The defendants allege the Doe 5 boys thought Michael's touching of him was accidental while they were wrestling, until their father suggested it was not. They add it was the Doe 5's oldest son, MS2, who originally suggested that Michael live with their family. In February 2013, Michael Jensen was tried and convicted of the sexual abuse of the Doe 1 children, JT and WT. During Michael's criminal trial, the Doe 2 son, ZW, testified under Rule 404B about his own sexual abuse by Michael. After additional children came forward, alleging they had been sexually abused by Michael, the church organized a support group meeting for their families in March 2013, in which some of the plaintiff families participated. UD1 attended the support meeting. after which he reported on the meeting to stake President Groh. The plaintiffs allege UD1 continued to keep President Groh informed of what he learned from the plaintiff families and of the conversations he had with John Doe 5's lawyer. The appendix record contains an email from UD1 to Groh that begins, "As promised, here is what he and John Doe 5 talked about last night," unquote. On September 16th, 2013, the plaintiffs filed their complaint in the circuit court against the church defendants and the Jensens, Chris, Sanderly, and Michael, alleging civil conspiracy, fraud, intentional infliction of emotional distress, and various negligence claims. They also asserted an assault and battery claim solely against Michael Jensen. On February 3, 2014, the plaintiffs filed an amended complaint naming UD1 as a defendant on their claim of civil conspiracy. Following extensive discovery, multiple motions for summary judgment were filed, as well as numerous motions in limina. During a status conference held on August 31, 2015, the circuit judge, expressing his concern regarding the impact of that 6-week trial would have on his docket, identified a need to find ways to shorten the trial's duration. On December 4, 2015, prior to its in limina rulings, the circuit court entered an order granting UD1's motion for summary judgment, finding the plaintiffs could not prove the elements of conspiracy against him. Through its order entered on December 30, 2015, the circuit court granted several of the defendants' motions in limina, effectively eliminating much of the plaintiff's evidence offered in opposition to the defendants' motions for summary judgment on the conspiracy claim. Although the circuit court had previously indicated its intent to allow the plaintiff's conspiracy claim against the remaining defendants to go to trial, the following day, December 31, 2015, the court entered an order granting summary judgment in favor of the remaining defendants on that claim. After observing in this order that it had eliminated much of the circumstantial evidence that the plaintiffs intended to use in support of their conspiracy claim, unquote, the circuit court found the plaintiffs had no direct evidence of a conspiracy and no evidence of a, quote, concerted action by the alleged conspirators, unquote, a, quote, common plan or mutual agreement by the alleged conspirators, unquote, or any evidence that, quote, the alleged conspirators combined and agreed to violate a duty owed to the plaintiffs, unquote. On January 11, 2016, the circuit court entered an order of final judgment pursuant to West Virginia Rule of Civil Procedure 54B concerning its summary judgment orders. The circuit court ruled these orders were final because they entirely disposed of all claims against UD1 and all conspiracy claims against all defendants. No party objected to the entry of this order. This appeal followed. 2. Standard of review. The plaintiffs have appealed 2 summary judgment orders. Our review is plenary. A circuit court's entry of summary judgment is reviewed de novo. To the extent other standards apply to our review of the circuit court's Rule 54B certification and its evidentiary rulings, those standards are set forth below. 3. Discussion. The circuit court certified its summary judgment orders under West Virginia Rule of Civil Procedure 54B. Following our consideration of the Rule 54B certification, we will then address the circuit court's in limina rulings and conclude with our review of the summary judgment decisions. A. Rule 54B certification. In its Rule 54B order, the circuit court found that its summary judgment orders had disposed of the only claim, conspiracy, asserted against UD1, as well as the conspiracy claim against all other defendants, and that there was no reason for delaying entry of final judgment with respect to those claims. As the circuit court explained, appellate review of these orders and necessary evidentiary rulings will promote judicial efficiency by maximizing the chance that this lengthy and complex case is tried only once, with the benefit of definitive rulings on the admissibility of certain evidence and the viability of certain claims. And B, the special nature of this case, where sexually abused children will be called upon to testify, strongly supports appellate review of these matters before trial. Testifying and reliving their abuse is re-traumatizing, and whatever appropriate steps are available should be taken to ensure that this happens only once. All parties assented to the circuit court's Rule 54B, ruling as being proper in meeting the criteria of Rule 54B at the time it was made. Notwithstanding the defendant's agreement to entry of Rule 54B, order below, and the fact that they did not file a motion to dismiss this appeal or cross-assign as error the circuit court's Rule 54B certification, they now argue that this interlocutory appeal under Rule 54B is improper because civil conspiracy merely extends liability for an underlying tort, which makes it inseparable from the merits of the underlying torts that remain pending below. For the reasons set forth below, we disagree. Our review of the circuit court's Rule 54B certification is guided by the following test. In reviewing a circuit court's certification under Rule 54B of the West Virginia Rules of Civil Procedure, this court applies to a 2-pronged test. First, we scrutinize de novo the circuit court's evaluation of the interrelationship of the claims in order to decide whether the circuit court completely disposed of one or more claims, which is a prerequisite for an appeal under this rule. So the second prong of the inquiry under the rule, whether there is any just reason for delay, this court accords the circuit court's determination considerably more deference than its first prong determination. The circuit court's assessment that there is no just reason for delay will not be disturbed unless the circuit court's conclusion was clearly unreasonable, because the task of balancing the contending factors is peculiarly one for the trial judge, who can explore all the facets of a case. Regarding the first province prong, the circuit court found that its summary judgment rulings had disposed of the plaintiff's conspiracy claim against UD1, which was the only cause of action asserted against him, and their conspiracy claim against all other defendants. We have previously recognized conspiracy as a separate claim, as we stated in Dunn versus Rockwell in 2009. Quote, the law of the state recognizes a cause of action sounding in civil conspiracy. The fact that a civil conspiracy claim requires an underlying tort or harm resulting from the conspiracy does not make it any less a claim that can be disposed of separately from the remaining cause of action. The defendants assert that civil conspiracy is inseparable from the merits of the underlying torts, is based on the same facts, and seeks the same recovery. While the same facts may be relevant to the conspiracy claim, as well as the negligent and intentional tort claims that remain pending below, this does not preclude the Circuit Court's Rule 54B certification of its final ruling on the plaintiff's conspiracy claim. Indeed, quote, when the mischief is accomplished, the conspiracy becomes important, as it affects that means and measure of redress. For the party wronged may look beyond the actual participants in committing the injury and join with them as defendants all who conspire to accomplish it. The significance of the conspiracy consists, therefore, in this, that it gives the person injured a remedy against parties not otherwise connected with the wrong. It is also significant as constituting a manner of aggravation, and as such tending to increase the plaintiff's recovery. Gosden v. Lewis, 1996, citation omitted. Further, a conspiracy claim enlarges the pool of potential defendants from whom a plaintiff may recover damages, and possibly an increase in the amount of those damages. Observing that there were additional damages are awarded on conspiracy claim, there must be evidence to support damages award. In the case at bar, the plaintiffs argue that, quote, conduct that establishes conspiracy liability, but not separate tort liability, could cause harms not recoverable on the separate tort claims, unquote. We have previously recognized the possibility of separate damages for conspiracy. In Slack versus Kanawha County Housing and Redevelopment Authority in 1992, after ordering the reinstatement of the verdict for the plaintiff's emotional injuries awarded on her invasion of privacy claim, we addressed the errors the plaintiff asserted concerning her conspiracy claim. In Slack, quote, the only damages the plaintiff proved were damages for emotional distress and mental anguish, unquote. We recognize that, quote, identicality of the damage claim asserted under the civil conspiracy theory, unquote, but declined to address, quote, whether from a substantive standpoint there was sufficient evidence to prove such a theory, unquote. On remand, we instructed that, quote, the plaintiff is free to develop the claim for civil conspiracy, but unless the damages were separate and distinct from those already obtained on the invasion of privacy verdict, there can be no recovery under Harless, unquote. Overruled on other grounds in Garnes versus Fleming Landfill Incorporation, 1991, finding that had jury been properly instructed on the appellant's conspiracy theory, they may well have returned a verdict for compensatory damages against Thatemio by virtue of the evidence of his participation in the conspiracy. While the deference this court affords to a circuit court's Rule 54B certification under the first prong of province is clear, we afford even greater deference in the circuit court's decision under the second prong of province. As indicated above, the circuit court found no just reason for delay because appellate review of its orders would, quote, promote judicial efficiency by maximizing the chance that this lengthy and complex case is tried only once, with the benefit of definitive rulings on the admissibility of certain evidence and the viability of certain claims, unquote. These proceedings, quote, will not be disturbed unless the circuit court's conclusion was clearly unreasonable, unquote. Under the authority set forth above, and upon giving the requisite deference to the circuit court's Rule 54B ruling, we conclude that there was no abuse of discretion in the determination that the summary judgment rulings completely disposed of the plaintiff's conspiracy claims. Further, we give substantial deference to and concur in the circuit court's conclusion that, quote, the special nature of this case, where sexually abused children will be called upon to testify, strongly supports appellate review of these matters before trial. Accordingly, we find no abuse of discretion in the circuit court's Rule 54B certification. We will exercise our appellate jurisdiction in this matter. B. In limina rulings. Having upheld the Circuit Court's 54B certification, we observe that, quote, where an appeal is properly obtained from an appealable decree, either final or interlocutory, such appeal will bring with it, for review, all preceding non-appealable decrees or orders, from which have arisen any of the errors complained of in the decree appealed from, no matter how long they have been rendered before the appeal was taken. Necessarily intertwined with the Circuit Court's summary judgment rulings entered in favor of the church defendants and the Jensen parents are its antecedent in limina rulings. Notwithstanding our holding in Rife, the church defendants strongly urged this court to refuse consideration of the Circuit Court's in limina rulings. Citing our finality rule, they argue that the plaintiffs cannot demonstrate that the in limina rulings, quote, were so integral that the conspiracy order as to give rise to the purported errors contained therein, unquote, that, quote, nothing in the Circuit Court's expressed reasons for granting summary judgment suggests that the outcome would have been different if some or all of the excluded evidence had not been excluded. So they're saying it didn't matter. Like, it's okay that they bypass that. And that there is no meaningful way for this court to determine that any excluded evidence, much less which evidence, resulted in the alleged error in the conspiracy ruling. The Jensen parents take a somewhat different stance. They first argue that this court should not review the in limina rulings, but then acknowledge that the instant appeal is, quote, tied up with the evidentiary rulings that have been decided, adding that any review of these rulings should be limited, quote, to the extent they impact the outcome of the summary judgment ruling on the conspiracy cause of action. Rejecting the notion that the in limina rulings are distinct from the summary judgment rulings, the plaintiffs maintain that this court can properly review these evidentiary rulings under Rife. They highlight the Circuit Court's statement in its summary judgment order that it had been, quote, eliminated much of the circumstantial evidence that plaintiffs intended to use in support of their conspiracy claim, unquote, through its in limina rulings. Although the defendants argue that any alleged error in the summary judgment rulings did not arise from the prior in limina rulings, we find that the circuit judge's comments made during the Rule 54B hearing indicate otherwise. Quote, I don't know how you get around the motions in limina. Aren't you going to have to look at those as part of the appeal? I don't know how you cut that out of it, unquote. It is clear that this court, as well as the in limina rulings and the summary judgment rulings, are inextricably entwined. Typically, a motion in limina is, quote, a pretrial request that the court not permit certain anticipated evidence to be admitted in the trial and not be seen or heard by the jury, unquote. While the circuit court's in limina rulings may have been made, in part, for such purposes, it is equally clear that these in limina rulings allowed the circuit court to evade review of that evidence and the attendant duty to draw all reasonable inferences therefrom in the light most favorable to the non-moving party, as is required of a court in ruling upon a motion for summary judgment. Other courts have cautioned against proceeding in such a manner. In C&E Services Incorporated versus Ashland Incorporated in 2008, the court found that, quote, a motion in limina should not be used to resolve factual disputes or weigh evidence. Rather, such should be accomplished through, quote, a motion for summary judgment with its accompanying and crucial procedural safeguards, unquote. Similarly, in Mid-America Tablewares Incorporated versus Moggy Trading Co. in 1996, the court determined that the sufficiency of evidence concerning lost profits was for summary judgment or judgment as matter of law, not a motion in limina, observing that motion in limina is not the appropriate vehicle for weighing the sufficiency of the evidence. Williams versus Johnson in 2010, motions in limina are designed to narrow the evidentiary issues at trial. In light of their limited purpose, motions in limina should not be used to resolve factual disputes, which remain the function of a motion for summary judgment. Ferguson versus Marshall Contractors Incorporated in 2000, finding trial judge had improperly used motion in limina to effectively make summary judgment rulings. While not expressly considering the propriety of utilizing the in limina rulings to resolve factual disputes, this court has addressed the effects of a circuit court's elimination of evidence through an in limina ruling to facilitate summary judgment. In San Francisco versus Wendy International Incorporated in 2007, the circuit court excluded the testimony of the plaintiff's causation experts through an in limina ruling, after which it, quote, went on to grant summary judgment to the defendant on the basis that the plaintiffs did not have sufficient evidence to support their claim, unquote. This court concluded that, having found that the circuit court erred in excluding both of the appellant's causation experts, we now find that the appellants made a sufficient showing on an essential element of the case that they had the burden to prove. Accordingly, because it now appears from the record that genuine issues of fact exist to be tried, we find that the circuit court erred in granting summary judgment. Similarly, in Buchanan Sales Company Incorporated versus Appalantic Corp. In 1985, the circuit court first granted the defendant's motion in limina, quote, to prevent the introduction of peril testimony concerning the various documents, contending that the court should not admit peril evidence and that the terms of the various contracts were unambiguous, unquote. The court later granted summary judgment in favor of the defendant. After analyzing the peril evidence rule, this court reversed the award of the summary judgment after determining that, quote, the motion in limina was erroneously sustained, unquote, and that, quote, the parties should have the opportunity to explain their agreements, unquote. Although the defendants contend that there is nothing in the circuit court's reasoning for granting summary judgment that would suggest a different outcome had some or all of the excluded evidence not been eliminated, we disagree. The fact that the circuit court first eliminated a large portion of the plaintiff's circumstantial evidence offered in support of their conspiracy claim before it granted the church's defendants and the Jensen parents' summary judgment motions on the claim that strongly suggests otherwise. While the defendants afford little significance to the circuit court's pronouncement that it had eliminated much of the plaintiff's evidence through its prior in limina rulings, we find the statement reveals precisely what the circuit court hoped to accomplish. Okay, and let me wrap my head around all this because this is like a lot. It sounds like they're trying to say this boy did these things and the church was covering it up. This is what it sounds like to me. I'm not a lawyer. I wish RFM was here so I could talk to him about this. Maybe he's already done an episode on this. I don't know. But it sounds like they're trying to say that the church was involved and they were covering it up, or they didn't make people aware that this was happening. And it sounds like the court is saying, because we don't want these kids to testify more than once, we're going to dismiss all the conspiracy evidence. And they're saying that's the wrong thing to do, that you should see it all together. I'm not a lawyer. That's just what I'm gathering, but we'll keep going. Turning to the circuit court's in limina rulings, we first observed that, quote, a trial court's ruling on a motion in limina is reviewed on appeal for abuse of discretion, unquote, from McKenzie versus Carroll Intern Corp. In 2004. Our consideration necessarily begins with a review of the evidentiary rules applicable to the circuit court's rulings. Although the circuit court's in limina rulings are sparse in terms of any factual or legal analysis, the order does reflect a cursory application of Rules 401 and 403 of the West Virginia Rules of Evidence. Under West Virginia Rule of Evidence 401, quote, evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action, unquote. Relevant evidence may be excluded, however, quote, if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. In all but one of the in limina rulings being challenged, the circuit court found, inter alia, that the evidence would be wasting time and would cause undue delay, which are Rule 403 considerations. The circuit court did not explain in its order why its evidence would be a waste of time or cause undue delay, nor did it offer any analysis as to why this evidence is unfairly prejudicial or how that unfair prejudice substantially outweighs its probative value. Importantly, however, wasting time and undue delay should not be employed to exclude relevant evidence whose probative value substantially outweighs the risk presented by these concerns. Indeed, notwithstanding the circuit court's stated desire to find ways to shorten what will clearly be a lengthy trial in this matter, care must be taken to ensure that efficiency considerations do not lead to the exclusion of highly probable evidence. Okay, so they're saying, yes, it's going to take a long time, but that's not a good reason in this case. Like, all the evidence has to be seen. Sympathizing with the district court's concern about the length and complexity of the trial, agreeing that, quote, the district court excluded the other crime evidence without sufficiently considering the importance of the evidence to the government's case, and finding that the district court had other tools available to it to ensure that the trial proceeded as expeditiously as possible. Johnson versus Ashby in 1987, recognizing trial courts' need to control length of trial, but also observing that it may be an abuse of the trial court's discretion to exclude probative, non-cumulative evidence simply because its introduction will cause delay, unquote. We bear these cautions in mind as we consider the circuit court's in limina rulings that have been challenged in this appeal. Number 1, exclusion of Utah sex offense evidence. The circuit court ruled that allegations of the church's influence in the juvenile criminal proceedings in Utah were based on Michael's cryptic boast to a friend, and other circumstantial evidence of similarly limited probative value, which was substantially outweighed by a danger of unfair prejudice to the defendants, as well as concerns rooted in confusing the issues, wasting time, and undue delay. The circuit court found a dissimilarity in conduct between Michael's criminal offenses in Utah and the instant abuse allegations, adding that the Utah court records contained more information than either the Jensen parents, Michael's paternal grandfather, or Bishop Swenson would have contemporaneously been aware of. Regarding the SBRA, which was part of the Utah proceeding, the circuit court found that there was no evidence that the Jensen parents or church leaders ever saw the SBRA. Therefore, it had low probative value that was substantially outweighed by its potential for confusing the issues, undue delay, and wasting time. The plaintiffs assert that these rulings are in error because the events in Utah marked the inception of the concerted action they have alleged. They insist that the direct evidence concerning Michael's early history of sex offenses in Utah is intrinsic to their claims, particularly where disputes abound regarding when the defendants had noticed that Michael was a risk to children, whether they concealed both the abuse and the risk, and whether Michael should have been sponsored as a fit babysitter for church families in West Virginia, or as a boarder in their homes. Regarding the circuit court's finding that this evidence would be a waste of time because the Utah offenses were too dissimilar to Michael's later abuse of children, the plaintiffs posit the question: what parents would not want to know that the person being proffered to babysit his or her child or board in his or her home had prior sexual offenses? And what parent would not think that persons with knowledge of these offenses had a duty to disclose that knowledge before urging unsuspecting parents to allow that person into their home and or to babysit their children? Great questions. Regarding the circuit court's acceptance of the Jensen's denial that they never saw the SBRA or knew of its contents, the plaintiffs assert this was a credibility determination made by the circuit court in the face of contrary circumstantial evidence that calls into question the veracity of the Jensen's denial. The plaintiffs further argue that it should be for a jury, not the circuit court, to decide whether there is a connection between Michael's Utah sex offenses and his later abuse of the minor plaintiffs and whether the church influenced the outcome of the proceeding in Utah through the involvement of Michael's paternal grandfather, who held powerful positions within the church. Maintaining that the contested facts concerning what happened in Utah, whether the conduct was serious, and whether it was predictive of Michael being a threat to reoffend were all disputed, the plaintiffs assert the circuit court erred in resolving these disputed facts in favor of the defendants before also finding that this evidence had limited probative value and would be a waste of time. Rejecting the plaintiffs' arguments, the defendants contend the circuit court did not abuse its discretion because the plaintiffs have no evidence that Michael, his parents, or any church leaders ever saw the SBRA or knew of its contents, and that the plaintiffs have distorted the record when they claim the Jensen parents knew Michael was a danger to children because they no longer allowed him to babysit his younger siblings. Arguing further, the defendants state that the circuit court properly excluded the SBRA, which has low probative value given the dissimilarities between Michael's Utah conduct and the instant abuse allegations, and which value was substantially outweighed by its potential for issue confusion, undue delay, and wasting time. The defendants contend that the plaintiffs have no evidence of church influence in Michael's Utah proceedings, that those persons involving in that proceeding, including the prosecutors, have testified that they were not influenced in their handling of Michael's prosecution, and that Michael's parents and grandfather participated in the proceeding as any parent or grandparent would in such circumstances. Based on our review of this evidence, we conclude that the circuit court abused its discretion in excluding evidence of Michael Jensen's juvenile criminal proceeding in Utah. Evidence of the Utah offenses, including the SBRA, are clearly relevant and probative of who knew what and when, which is the heart of the plaintiff's conspiracy claim, and is probative of notice of Michael's risk to reoffend sexually. Moreover, it is neither speculative nor unreasonable to conclude that a jury might infer that Michael's parents had access to information associated with their minor son's criminal proceeding, including the SBRA, which cautioned that Michael should be supervised with any female, including his young sisters, until his therapy was completed and the risk reduced. What purpose would such a warning serve if it were not shared with the very persons intended to implement the protections addressed by the caution? Moreover, the parties' experts have relied, in part, on the SBRA in rendering their opinions. Further, regarding the church's alleged influence in the proceeding, it is difficult to ignore Michael's friend J.C., who testified that Michael said that he had been in legal trouble with a girl in Utah before moving to West Virginia, but his grandfather, quote, was in a leadership position for the church and helped take care of whatever needed to be taken care of, unquote. While the circuit court found this statement to be merely a boast, Michael had declined to testify in this matter. Thus, there is no basis for such conclusion. Just because highly probative evidence may prejudice the opposing party, that basis alone does not warrant the exclusion of such evidence, which is the case here. Moreover, concerns about the length of trial do not warrant the exclusion of this evidence, based on waste of time, undue delay, or confusion for a jury. It will be for a jury to resolve any factual disputes associated with this evidence, draw reasonable inferences from this evidence, as it may, and determine whether its evidence supports the plaintiff's conspiracy claim. 2. Exclusion of evidence of Michael Jensen's alleged assault of J.M. in 2007. The Circuit Court found the evidence of Michael Jensen's alleged assault upon J.M. in 2007 to be of limited probative value for purposes of establishing notice that Michael was a danger to young children, and that any probative value of this evidence was substantially outweighed by its potential for issue confusion, undue delay, and, quote, wasting time during what is expected to be a long trial, unquote. The plaintiffs argue the Circuit Court erred by rejecting their argument that whether this evidence provides notice that Michael was a risk to a range of potential victims is a jury question. Arguing further, the plaintiffs maintain that Sandra Lee Jensen, who was a church officer at the time, connected to the J.M. assault with Michael's offenses in Utah, bringing both matters to the attention of Bishop Whitcomb, all of which occurred before Michael was, quote, placed as a babysitter for the Doe 1 family in November 2007, the Doe 2 family in February or March of 2008, and into the homes of other plaintiffs hereafter. The defendants respond that no local church leader knew anything about the J.M. incident, that at most, Sandra Lee Jensen may have mentioned this incident in a passing comment to Bishop Whitcomb. They further argue it was not until J.M.'s deposition in May 2014 that either the Jensens or anyone else learned that the incident had been anything but consensual. Finally, they contend that regardless of what they knew about the incident, it, quote, would not act as a predictor that Michael might abuse young children, unquote. We find the relevancy and probity of this evidence outweighs any concern for issue confusion, undue delay, or wasting time. This is simply another piece of evidence from which the jury could infer a conspiracy to conceal incidents of Michael's sexual abuse of others, including J.M., and to suppress information on the ongoing danger and the threat that he posed. Certainly Sandra Lee, who is alleged to be part of the conspiracy, and who was then serving as Relief Society president, had concerns at the time, prompting her to ask J.M. whether she was okay and, quote, do we have a problem, unquote. Mrs. Jensen also reported the incident to Bishop Whitcomb during a conversation in which she raised the topic of Michael's offenses in Utah. Accordingly, we find that the Circuit Court abused its discretion in excluding this evidence. 3. Exclusion of any reference to an alleged 2006-2007 Stake High Council meeting. The plaintiffs have circumstantial evidence that a Stake High Council meeting occurred in either 2006 or 2007, during which, inter alia, Michael Jensen's abuse of a younger sister was allegedly discussed, and Stake President Grow used UD1 to monitor Chris Jensen and report back to him, which UD1 agreed to do. The Circuit Court excluded this evidence, finding the plaintiffs had no, quote, first-hand evidence of such a meeting, unquote. And the probative value of the plaintiff's hearsay evidence, even if the court were to find it admissible, was substantially outweighed by a danger of undue delay and a waste of time. In making this particular in limina ruling, the Circuit Court referenced, without discussion, its earlier order granting summary judgment in favor of UD1. The Circuit Court found in its prior order that UD1 was indisputably not a member of the Stake High Council until 2008, that the transcript of plaintiff's counsel's interview of UD1 reflected that UD1 did not specify a date for this Stake High Council meeting, that everyone who was indisputably a member of the Stake High Council at the time had denied that any such meeting took place, that the plaintiff's assertion that the meeting was prompted by Michael's abuse of a younger sister was not supported by the record, and that the only record evidence of a sexual incident between Michael and a younger sister was a subsequent incident that occurred in 2010 with his then 12-year-old sister, KJ. The plaintiffs argue that there is extensive evidence that the meeting took place within the time frame they allege, including separate conversations that John Doe 5 had with Stake President Grow, President Grow's executive secretary at the time, Tony Nagel, and UD1. They allege UD1 told multiple plaintiffs about these stake discussions during a parent support group meeting in 2013, referencing the 2007 timeframe both then and when he was interviewed by the plaintiff's counsel. Rejecting these arguments, the defendants essentially echo the Circuit Court's findings, including that persons who served on the Stake High Council during that timeframe have all denied that such discussion regarding the Jensens ever took place. We find the Circuit Court abused its discretion by discrediting the defendant's denial that this meeting took place, when the record contains circumstantial evidence to the contrary. While the evidence is clearly conflicting, it will be for the jury to assess the credibility of witnesses, to determine whether the Stake High Council meeting took place, and, if so, whether concerns regarding Michael's abuse of others was discussed. A jury's resolution of this conflicting, but relevant and probative evidence will necessarily bear on who knew what and when, whether church leaders were of notice of the risk that Michael posed, and whether the evidence supports the plaintiff's conspiracy claim. 4. Exclusion of any reference to Michael Jensen's sister, RJ, allegedly exhibiting signs of sexual abuse. The Circuit Court found that there is no evidence that abuse of RJ was, quote, discussed at a High Council meeting, unquote, or that Michael was the abuser, even if RJ had been abused. It then concluded that, quote, very low probative value of plaintiff's circumstantial evidence of the alleged abuse of RJ is substantially outweighed by its potential for confusing the issues, undue delay, and wasting time, unquote. The plaintiffs contend the circuit court misunderstood their intended use for this evidence, which is not to argue that RJ was abused. Rather, they contend that she, quote, exhibited well-accepted signs of abuse, unquote, at the time when both Jensen parents held high positions within the church, were aware of their son's history of sexual offenses, and when Sandra Lee Jensen, who was aware of this incident, was offering Michael's babysitting services to church families in her role as Relief Society president. The defendants counter that even if RJ's behavior were suggestive of prior sexual abuse, this evidence has limited, if any, probative value because the plaintiffs do not allege that any church leader was aware of the incident. There was no attempt to conceal the event. And the Jensen parents never interpreted RJ's behavior as being indicative of sexual abuse by anyone, including Michael. We find the probative value of this evidence outweighs any concerns for issue confusion, undue delay, or wasting time. Having previously found that the plaintiff's circumstantial evidence concerning the Stakeout Council meeting in the 2006-2007 timeframe was inappropriately excluded from the circuit court, the relevancy and probative value of this evidence concerning RJ becomes more clear. Although the defendants argued the plaintiffs had concocted this theory of sexual abuse of RJ, if the jury finds that there was a 2006-2007 Stakeout Council meeting during which the abuse of a Jensen daughter was discussed, the jury could conclude that RJ was that daughter, and that related concerns prompted Stake President Groh to ask UD1 to monitor Chris Jensen. Accordingly, we find the circuit court abused its discretion by excluding this evidence. 5. Exclusion of 1999 purported helpline form document. As part of the evidence supporting their conspiracy claim, the plaintiffs plan to offer at trial a helpline form document to show how the church's abuse prevention and response systems are intended to protect the church from liability rather than to prevent abuse, as the church proclaims. The plaintiffs state this document was provided to their counsel by unnamed witness 1, who has averred that she telephoned the church's helpline in 1999 concerning an abusive situation, and that when the documents she had forwarded were later returned to her, this particular form document was included. Although the form appears on its face to be an instruction sheet for helpline workers taking calls, the circuit court excluded this form, observing that the only helpline call made in the instant matter was made by Bishop Vincent, more than 12 years after the date on the form. The lower court further found the document to be unauthenticated hearsay and irrelevant. While this form is very much in dispute, the church defendants assert, quote, even the purported helpline form, produced by plaintiffs, unquote, supports their position that the purpose of the church's helpline is, quote, to assist church bishops and stake presidents in ministering to victims and affected families in abuse situations, and to ensure that they comply with all applicable reporting laws, unquote. Although the defendants champion the exclusion of this form at trial as being irrelevant and unauthenticated, they also claim it reflects the church's vigorous policy of protecting and helping abuse victims. Conversely, the plaintiffs contend that they can authorize this form, which is relevant and supportive of their conspiracy claim. This alleged helpline form warns that helpline, quote, personnel should never advise a priesthood leader to report abuse. Counsel of this nature should come only from legal counsel, unquote. The plaintiffs argue their intent is not to show that this form was used when Bishop Vincent telephoned the helpline in 2012, but to support their claim of institutional concealment and their position that the helpline was implemented to protect the church from civil liability rather than simply to protect victims from sexual abuse. They add the form as indicative of a, quote, general strategy in responding to assertions of sexual abuse in the Mormon community, which is as true today as it was when the helpline was first implemented in the 1990s. The church defendants refute this assertion, arguing that any notion with its helpline procedure has not changed since 1995 is, quote, flatly contradicted by the record, and that, quote, witnesses familiar with the helpline procedure testified that no such form is used today, and that they have no knowledge of the purported helpline form or any written protocol, unquote. While this particular evidence, as well as other evidence in the appendix record, would support the inference urged by the plaintiffs, it also arguably supports the church defendants' position that this form is indicative of the church's purported laudatory policy and goal of preventing and protecting abuse victims. Although the defendants contend this form document has no bearing on the plaintiff's conspiracy claim, we find a jury could reasonably infer that the defendant's silence, in the face of repeated reports of alleged abuse by Michael Jensen, while simultaneously holding him out as a suitable babysitter and boarder to church families, was consistent with this form document's warning to, quote, never advise a priesthood leader to report abuse, unquote. Accordingly, we find this document to be relevant and probative to the plaintiff's conspiracy claim. With that said, this court does not know by what means the plaintiff will seek to admit this evidence at trial. In other words, the circuit court must determine at trial whether the plaintiffs can authenticate the document, as they aver they can, and whether they can overcome the defendant's evidentiary objections in that regard. 6. Church's annotation system. In essentially 2 sentences, the Circuit Court excluded evidence relating to the Church's annotation system, finding that, quote, using an internal record-keeping mechanism against the Church would create First Amendment concerns, unquote, without offering any further explanation or analysis as to what that concern might be. The annotation system is part of the Church's abuse, quote, prevention and response, unquote, procedure for annotating records of members who commit child abuse or might otherwise pose a threat. The Circuit Court concluded that because the Church did not use this annotation system to annotate Michael Jensen's church membership record, any probative value was substantially outweighed by, quote, the potential for confusing the issues, undue delay, and wasting time, unquote. The plaintiffs assert the Circuit Court erred in this regard, notwithstanding its further ruling that the Church defendants could not use the annotation system in their defense. The plaintiffs argue the Church has, quote, touted its abuse response and prevention procedures as the gold standard, unquote, which is the opinion of the Church defendants expert, exceeds the secular standard of care for youth-serving institutions. A part of these procedures is the Church's helpline, as discussed above, as well as its annotation system. The plaintiffs plan to offer evidence at trial that Bishop Swenson did not annotate Michael Jensen's church membership record following his admission to sex offenses in Utah, and had he done so, church leaders in West Virginia would have received earlier notice of Michael's sex offenses, which could possibly have prevented the abuse of the minor plaintiffs through the Church's secular duty to warn. Arguing further, the plaintiffs state that this evidence is relevant and is not a, quote, waste of time, unquote, when they have alleged the Church's failure to warn as part of the alleged conspiracy. Rather than substantially challenging the Church's failure to annotate Michael's record following his Utah offenses as a matter of church doctrine, the plaintiffs assert their defendants argue the annotation system is irrelevant to Michael Jensen because it only restricts the types of church callings a congregant can have, and Michael's abusive conduct was out of church conduct. The plaintiffs counter that church leaders placed him as a babysitter in several homes, as a boarder in others, and as an unsupervised substitute teacher in the Church's primary class of 4-year-old children. Regarding the defendants' argument that their evidence demonstrates that only adult records are annotated, the plaintiffs point to contrary evidence in the appendix record. And in response to the defendants' assertion that annotating Michael's record would have made no difference because it would only have been seen by his bishop and stake president, the plaintiffs point to the Church's Rule 30b-7, witness who testified that the purpose of notifying the bishop and stake president is so that they can, in theory, take steps to protect potential victims. We find the Circuit Court abused its discretion in excluding evidence of the existence of a system that the defendants have described as meeting, if not exceeding, the Church's secular duty as a youth-serving organization. This evidence is not only relevant and probative of the Church defendants' defense, it is equally relevant and probative to the plaintiff's claim, particularly when notice and the Church's failure to warn is part of the conspiracy claim. Any factual disputes presented by the evidence at trial may be resolved by a jury. Accordingly, we conclude that the probative value of this evidence is outweighed by any potential for confusion of the issues, undue delay, and wasting time, and it was error for the Circuit Court to have excluded this evidence. C. Partial summary judgment in favor of church defendants and the Jensen parents on conspiracy claim. In its order entered on December 31st, 2015, the Circuit Court awarded partial summary judgment in favor of these defendants pursuant Rule 56 of the West Virginia Rules of Civil Procedure. Under this rule, a party is entitled to summary judgment if it can show, quote, that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law, unquote. Specifically, the Circuit Court granted summary judgment on the plaintiff's conspiracy claim after observing that it had, quote, eliminated much of the circumstantial evidence that plaintiffs intended to use in support of their conspiracy claim, unquote, and that the plaintiffs had no direct evidence of a conspiracy. In its rather cursory 5-page order, the Circuit Court found that the plaintiff's conspiracy claim was based on speculation, conjecture, cumulative inferences, and was so implausible that no reasonable juror could conclude that local church leaders in 2 different states conspired with Michael Jensen and his parents over a number of years to conceal his abuse or to, quote, actively facilitate his pedophilia by trumpeting his moral worthiness to the congregation and obstructing a criminal investigation, unquote. The Circuit Court concluded it was, quote, insufficient for plaintiffs to show that multiple people happened to do the same thing or refrain from doing the same thing, particularly when they all deny knowing that Michael Jensen was an abuser and when the church condemns child sexual abuse, unquote. And seeking a reversal of the Circuit Court's ruling, the plaintiffs assert the lower court engaged in impermissible fact-finding by weighing conflicting evidence, resolving credibility disputes, dismissing and resolving doubts, and drawing inferences in favor of defendants when those inferences should have been drawn in their favor as the non-moving party. Arguing further, the plaintiffs assert that the lower court substantiated its judgment, for that a jury on the weight, existence, and sufficiency of plaintiff's evidence through its in limina rulings, maintaining that whether there were sufficient evidence for trial under the procedural requirements and guidelines for deciding a Rule 56 motion, not as a motion in limina. The plaintiffs state that their conspiracy claim is based on intentional acts and intentional torts, and that the defendants conspired with Michael Jensen to promote and create opportunities for Michael Jensen to babysit and live in homes with small children, cover up incidents of sexual abuse by minors by Michael Jensen, prevent disclosure of Michael Jensen's sexual abuse by young children, thwart and/or hinder enforcement actions by civil and criminal authorities to prevent further abuse and protect minor children, engage in the other conduct therein. Based on these actions, the defendants conspired for the unlawful purpose of facilitating Michael Jensen's criminal and tortious acts against the minor plaintiffs, and for the further unlawful purpose of concealing and suppressing information on the danger and threat that Michael Jensen posed to unsuspecting children. The plaintiffs assert that when a conspiracy produces a tort, quote, every conspirator is liable for that tort, including a conspirator who promoted but did not commit the tort, unquote. They further argue that, quote, once the conspiracy is formed, all of its members are liable for injuries caused by any unlawful acts performed pursuant to and in furtherance of the conspiracy, unquote. Although a principal cannot conspire with its agent, the plaintiffs assert, quote, a corporation can act only through its agents or employees, unquote. Therefore, when the Jensen parents, quote, were not acting as church agents, they were members of the conspiracy in their own right and could conspire with the church, unquote. And when they were, quote, acting as agents of the church, then their acts were on behalf of the church and the church's participation in the conspiracy, unquote. The plaintiffs add that even if the Jensens are considered to have been agents of the church at all times, which no one claims, a civil conspiracy requires only 2 members, and Michael Jensen was always a member of the conspiracy. Discounting the plaintiffs' arguments, the defendants contend that the plaintiffs have built their conspiracy claim on, quote, layers of unreasonable inferences, unquote, which are so implausible that no reasonable jury could conclude otherwise. They maintain that there is no evidence from which a jury can reasonably infer a preconceived common agreement to cover up or minimize any abuse or identify any concerted action in furtherance of a conspiracy. Arguing further, they state that, quote, at worst, there were unrelated incidents of ordinary negligence by individual actors, unquote, which, if proven, would allow the plaintiffs to recover on their remaining negligence and fraud claims. The church defendants insist, with the possibility of a single exception, they were not involved with the babysitting and living arrangements that resulted in the abuse. They contend the plaintiff's theory that the conspirators facilitated and created opportunities for Michael to have access to children that he could then sexually abuse lacks any evidentiary support and is, quote, utterly unreasonable and unbelievable on its face, unquote. In addition to echoing many of the church's defendants' arguments, the Jensen parents add that there was no conspiracy of silence because their alleged co-conspirators had no reason to believe Michael had sexually abused any children, and they were unaware of Michael's babysitting activities. They further argue that RJ was never abused by anyone, that Bishop Whitcomb assigned Sandra Lee Jensen as the Relief Society president and advanced Michael in the church's Aaronic priesthood at a time when he had no knowledge of Michael's offenses in Utah, and that even if the alleged 2006-2007 Stake High Council meeting occurred, such event does not prove they were part of a conspiracy. In addition, they assert there is no evidence that the alleged co-conspirators were aware of any sexual abuse committed by Michael, except the possible abuse of ZW that was allegedly disclosed to them and to Bishop Fischel in 2008. They add that there is no evidence of a conspiracy of silence related to Michael's abuse of his younger sister, KJ, when they, quote, immediately kicked Michael out of the house, which would have raised questions, unquote, and given that they also spoke to Bishop Vincent about the incident, asking him to help Michael. The Jensens state that, at worst, the evidence shows that different people conceivably knew, quote, bits and pieces of alleged misconduct by Michael, and there is no evidence of some grand scheme to conceal this misconduct, no evidence of any agreement to cover up, not to report, or to prevent disclosure, unquote. It is axiomatic that, quote, summary judgment is appropriate if, from the totality of the evidence presented, the record could not lead to a rational trier of fact to find for the non-moving party, unquote. Further, as we held long ago, quote, summary judgment must be denied if there is a genuine issue as to a material fact, unquote, and that, quote, the question to be decided on a motion of summary judgment is whether there is a genuine issue of fact and not how that issue should be determined, unquote. We previously articulated guidelines for evaluating a motion of summary judgment as follows. The circuit court's function at the summary judgment stage is not, quote, to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial, unquote. Consequently, we must draw any permissible inferences from the underlying facts and in the most favorable light of the party opposing the motion. In assessing the factual record, we must grant the non-moving party the benefit of inferences as, quote, credibility determinations, the outweighing of the evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of a judge, unquote. Applying these guidelines and precepts to a review of the circumstantial evidence previously excluded by the circuit court, as well as all other evidence, readily demonstrates the existence of a myriad of genuine issues of material fact that they should have precluded entry of summary judgment. Indeed, other than the parties' identities and Michael Jensen's convictions in West Virginia, there appear to be very few facts upon which the parties agree. Nearly every factual allegation is contested in some fashion, whether by inconsistencies between interviews, depositions, and affidavits, often from the same individuals, or interpretations of the evidence, or the inferences to be drawn from that evidence. For instance, the plaintiffs contend the conspiracy to protect Michael Jensen and to conceal his offenses began after he was charged with felony sex offenses in Provo, Utah as a teenager. They discuss various facts in support of this theory, including the involvement in that proceeding by Michael's paternal grandfather, who held a powerful position within the church in Provo. They also cite the testimony of defense expert Frank Iannelli, who testified that the charges against Michael in Utah were reduced more than commonly done, that there were numerous other atypical factors in the proceeding, and that Michael received a lenient punishment without follow-up consequences. Conversely, the defendants point to Mr. Iannelli's April 3, 2015 witness statement in which he stated that the outcome of Michael's case in Utah, quote, was typical for such a case, unquote. Other disputed issues of material fact involves the parties' basic disagreement regarding the precise nature of Michael's offenses in Utah, and whether they provided notice of his risk to re-offend sexually. The plaintiffs describe Michael's offenses, which resulted in his arrest at his middle school and being charged with 2 felony sex offenses, as him waiting for each victim, pinning her against a wall, and grabbing her breasts and buttocks against her will, a description that is consistent with the victim's statements in the appendix record. Conversely, the defendants describe the incident as Michael briefly groping 2 peer-aged girls over their clothes, which the Jensen parents contend were, quote, offenses that were not atypical for a male of his age, unquote. Additional disputed facts in the alleged conspiracy timeline include Sandra Lee's report of the JM incident to Bishop Whitcomb, whether there was a link-up in her mind between the incident and Michael's offenses in Utah, and whether she conveyed the same to Bishop Whitcomb, and the concern she expressed to JM, asking if she was all right and whether they had a problem. Michael's alleged assault of JM is described above and will not be repeated here. It will be for a jury to make credibility determinations in this regard. There are also disputed issues of material fact concerning the alleged State High Council meeting, during which the plaintiffs contend that the church leaders discussed the issue of sexual abuse and the Jensens in the 2006-2007 timeframe. The defendants assert that all those who would have participated in the meeting have denied it ever occurred, that UD1 could not have participated because he was not placed on the Stake High Council until 2008, that John Doe 5's testimony that Stake President Grow told him that such a meeting took place is self-serving hearsay, and that no such discussion could have happened because no church leader learned of Michael's abuse until after his arrest in 2012. The plaintiffs counter that John Doe 5 testified during his deposition that Stake President Grow confirmed to him such discussion about the Jensens had taken place in the time frame in question, and that he had asked UD1 to keep an eye on Chris Jensen and report back to him. And that President Grow's executive secretary also confirmed that these stake discussions concerning the Jensens took place. The plaintiffs also point to UD1's interview by their counsel during which he stated, quote, I am on councils, unquote, referring to Stake High Councils, where the issue of sexual abuse of Michael was discussed during the relevant time frame, as contrasted with the conflicting statement made by UD1 during his subsequent deposition. They also point to the deposition of those adult plaintiffs who testified to having similar disclosures made to them by UD1. These and many other genuine issues of material fact arise out of the plaintiff's circumstantial evidence. Although the circuit court stated the plaintiffs have no direct evidence, none is required to prove their conspiracy claim. As we previously explained, quote, circumstantial evidence is information that tends directly to prove or disprove not a fact and issue, but a fact or circumstance from which, either alone or in connection with other facts and circumstances, one may, according to the common experience of mankind, reasonably infer the existence or non-existence of a fact that is an issue. In West Virginia and in federal courts, civil and criminal verdicts may be based entirely upon circumstantial evidence, unquote. Further, circumstantial evidence, especially evidence of concerted activity directed toward achievement of a common goal, is as probative as direct evidence, unquote. I'm going to skip around here for a second. Direct proof of such an agreement is rarely available since conspiracies are by their very nature secretive. Thus, the existence of a conspiracy may be inferred throughout the combination of common sense and circumstantial evidence. As is true in criminal conspiracies, agreements in civil conspiracies will not easily be shown by direct evidence, but may be inferred from circumstantial evidence. A conspiracy is rarely susceptible of direct proof. Instead, it is established from circumstantial evidence and inferences drawn from evidence, coupled with the common sense knowledge of the behavior of a person in similar circumstances. Courts have long held that conspiracies may be inferred from circumstantial evidence. No formal or express agreement need be shown. Agreeing with the defendant that the circumstantial evidence is as probative as direct evidence, and that conspiracy can rarely be proved as direct evidence. Inasmuch as a conspiracy may be proven by circumstantial evidence, we consider the evidence the plaintiffs have offered, including the circumstantial evidence that had been excluded by the circuit court. And undertaking that task, we are mindful that under West Virginia law, a civil conspiracy is a combination of two or more persons by concerted action to accomplish an unlawful purpose or to accomplish some purpose not in itself unlawful by unlawful means. The cause of action is not created by the conspiracy, but by the wrongful acts done by the defendants to the injury of the plaintiff. And these are more further notes. A civil conspiracy is a legal doctrine under which liability of a tort may be imposed on people who did not actually commit a tort themselves, but who shared a common plan for its commission with the actual perpetrators. And then it goes on and it's giving other examples as we saw before. But I'm just going to keep going. Although the defendants assert the conspiracy claim fails because failure to warn is negligence, and persons cannot conspire to be negligent, the plaintiffs have alleged a conspiracy to commit intentional torts and to accomplish the unlawful purpose of concealing and harboring a, quote, sex offender, unquote, that resulted in harm to them. A jury, after sitting through the evidence, resolving credibility disputes, and drawing all reasonable inferences from the evidence, could conclude, as the plaintiffs argue, that the defendant's conduct in ignoring, minimizing, trivializing, and denying the abuse, actively concealing and keeping silent about the abuse, promoting and misrepresenting Michael Jensen as an exemplary and trustworthy member of the church, promoting and misrepresenting him as fit to babysit for or live in a house with young children, and facilitating the abuse by engaging in the foregoing and placing him in homes with young children as a babysitter or boarder, were taken in furtherance of the conspiracy's unlawful purposes. Moreover, as the plaintiffs contend, quote, even if some of those acts, taken independent of the conspiracy, would be lawful, unquote, a jury could still find the conspiracy was proven. And then it goes on to say, in order for civil conspiracies to be actionable, it must be proved that the defendants have committed some wrongful act or have committed the lawful act in an unlawful manner to the injury of the plaintiff, unquote. Regarding the defendant's arguments that the agent cannot conspire with his or her principal, even if the Jensen parents were found to have been agents of the church at all times, the conspiracy claim is not defeated because a civil conspiracy requires only two members. Michael Jensen is alleged to have always been a member of the conspiracy. So if at least one other person knows about it, then it can be considered a conspiracy. Those are my words, not part of the slides. The evidence discussed above serves to highlight but a few of the innumerable issues of material fact in this matter and conflicting inferences being drawn by all parties from those disputed facts. It will be for a jury, not the circuit court of this court, to decide whether there was a conspiracy after resolving the disputed facts, making the necessary credibility determinations, and determining what was known by whom and when, and what those persons did with the information they had, and for what purposes. It will also be for a jury to determine whether the evidence proves a conspiracy that resulted in the harm to the plaintiffs. Skirting its duty to allow a jury to address the multitude of disputed factual issues present in this case, the circuit court wrongly invaded the jury's province by resolving these factual disputes and making credibility determinations. And when it credited the defendants' denials and their alternative facts in the face of countervailing evidence, the circuit court violated a long-established standard of resolving doubts in favor of the non-moving party. Despite the defendant's assertion that the plaintiff's, quote, far-fetched conspiracy theory is utterly implausible, unquote, and that, quote, no reasonable jury will draw the outlandish inferences necessary to find in plaintiff's favor, unquote, the plaintiffs have aptly argued neither the circuit court's presumption of good faith by a religious institution, based on its public pronouncements, nor its dismissal of an 8-year record of contrary conduct, as multiple church officials just happening to do the same thing with respect to Michael Jensen, should have supplanted the jury's consideration of the evidence, which was more than sufficient to support an inference of conspiracy. This appeal is not about whether the plaintiffs will prevail on their conspiracy claim at trial, but whether they have alleged sufficient evidence to survive summary judgment on that claim. We agree that they, quote, cannot create a genuine issue of material fact through mere speculation or the building of one inference upon another, unquote. Although the circuit court found the plaintiff's evidence to be speculative, and the defendants contend the plaintiff's evidence is nothing more than unreasonable, cumulative inferences, the necessary basis for granting summary judgment is clearly not present in this case. Having found the circuit court erred at excluding the plaintiff's circumstantial evidence in support of their conspiracy claim, and upon our consideration of that evidence, as well as all other evidence relied upon, we find there are genuine issues of material fact for trial. Drawing all permissible inferences from the facts in the light most favorable to the plaintiffs and leaving all factual disputes and credibility determinations to the jury, we conclude that the circuit court erred. Accordingly, we reverse the circuit court's order granting summary judgment in favor of the church's defendants and the Jensen parents on the plaintiff's conspiracy claim. D. Summary judgment in favor of UD1. Through its order entered on December 4, 2015, the circuit court granted summary judgment in favor of UD1, finding the plaintiffs could not prove the elements of conspiracy against him. For the reasons set forth below, we disagree. The circuit court determined that to the extent UD1 was an agent of the church, he could not conspire with his principal, that plaintiffs had not produced any evidence that would create a genuine issue of material fact to whether UD1 joined a conspiracy to facilitate or conceal Michael Jensen's abuse of children. That even if UD1 had knowledge of Michael's abuse of children and failed to disclose it, he had no duty to warn. That there is no evidence his silence enabled or assisted someone who had such a duty. That UD1's attendance at the victim's parents' support meeting in 2013 was not evidence of furthering the alleged conspiracy where John Doe 5 invited UD1 to that meeting and knew UD1 would be reporting on the meeting to stake President Grow. And that even if UD1 made statements during his deposition that contradicted statements he had previously made when interviewed by the plaintiff's counsel, Michael's crimes were already known at this juncture. Therefore, UD1's actions could not have been taken to keep Michael's misconduct a secret. The plaintiffs assert that in making these findings, the circuit court clearly engaged in impermissible fact-finding to conclude as a matter of law that no reasonable juror could infer from UD1's conduct that he had agreed with other church officials to conceal Michael Jensen's conduct, which facilitated harm to the minor plaintiffs. In support of their argument that UD1 was a participant in the alleged conspiracy beginning in 2006-2007, they contend that their evidence shows his knowledge of stake discussions around that time regarding Michael's abuse of a younger sibling and possibly another girl. UD1's monitoring of Chris Jensen during that same time period at stake President Grow's request, including making reports back to President Grow, his inside knowledge of Michael's Utah offenses, and his decision not to seek medical care for his 2-year-old son who came home from childcare conducted in the Jensen home in 2008 with a swollen penis and abrasions on his inner thighs when it was physically impossible for his child to have self-inflicted the injuries. The plaintiffs also point to UD1's placement on the Stake High Council in 2008, his email to John Doe 5 in 2013, reflecting that he and his wife believed in 2008 that Michael had abused their son and had confronted the Jensen parents, but, quote, nothing was done, unquote. His attendance at the Parent Support Group meeting in 2013, and his report on the meeting to stake President Grow, his forwarding of private emails he exchanged with John Doe 5 concerning the abuse and this lawsuit to stake President Grow, and the change of his accounts of these various events to align himself with the church's defense. Notwithstanding the factual allegations recounted above, UD1 argues that the circuit court correctly found that the plaintiff's conspiracy claim against him fails, as a matter of law, because there is no genuine issue of fact relating to whether he entered into a conspiratorial agreement, whether there was concerted action, or whether he committed an unlawful act or pursued an unlawful purpose. He further argues that even if he took all of the actions outlined above, none were either unlawful or done for an unlawful purpose. He further argues that failure to warn is not unlawful unless he had a duty to warn, and he had no such duty, which is one of the biggest mistakes the church has ever made, to make their clergy not have to report the abuse to any law enforcement. We first address the circuit court's finding and UD1's argument that because he did not owe a duty to the plaintiffs to warn, therefore he could not be found liable for conspiracy. Critically, neither UD1 nor the circuit court have cited any authority for the proposition that UD1 had to owe an independent duty to the plaintiffs before he could be found liable for conspiracy, which is the only claim that has been asserted against him. While this court has said that, quote, the proponent of a civil conspiracy claim must produce at least circumstantial evidence that each member of the alleged conspiracy shared the same conspiratorial objective and mutual agreement, unquote, we have not said that each member of the conspiracy must independently owe a duty to the plaintiff. As we have explained, quote, every conspirator is liable for the tort, including a conspirator who promoted but did not commit the tort, unquote. Further, there were times during the course of the alleged conspiracy that UD1 served on the church's stake high council. In that leadership role, he may have possessed a duty to other church members, including the plaintiff's families, which the circuit court also did not address. In addition, we disagree with the circuit court's findings that the plaintiffs have no evidence that UD1 enabled or assisted someone who did not have such a duty. A jury could reasonably infer from the plaintiff's circumstantial evidence, some of which is outlined above, that UD1 did enable and assist those who had such a duty. It will be for a jury to resolve all evidentiary disputes and make credibility determinations in this regard. Moreover, one can conspire, quote, to accomplish an unlawful purpose or to accomplish some purpose not in itself unlawful by unlawful means, unquote. Contrary to UD1's argument, this does not imply that each member of the conspiracy must engage in unlawful acts. And then it gives some evidence, finding civil conspiracy actionable if it be proved that the defendants have committed some wrongful acts or have committed a lawful act in an unlawful manner to the injury of the plaintiff. When the purpose of a combination is illegal, every action in furtherance of it is illegal. Acts that are themselves illegal lose their character when they become constituent elements of an unlawful scheme, unquote. As with the other defendants, the circuit court faults the plaintiffs for not having any direct evidence that UD1 agreed to join the conspiracy or possessed personal knowledge of a conspiracy. The circuit court found the plaintiff's circumstantial evidence of UD1's participation in the alleged conspiracy to be, quote, too conjectural and speculative to raise an issue of fact, unquote. However, much of the plaintiff's evidence came directly from UD1, as recounted in the deposition testimony of several plaintiffs, and as reflected in UD1's email exchanges with certain plaintiffs, and the statements he made when interviewed by plaintiff's counsel. In addition to the circuit court's credibility, determinations being improper, and, quote, agreement need not be expressed, but may be based upon evidence of a course of conduct from which the agreement to act in concert may be implied, unquote. And then it gives an example. The agreement need not be expressed, formal, or definitive. Evidence establishing a tacit understanding among the conspirators to further a common purpose is sufficient. This circuit court also found that neither UD1's participation in the parent support group meeting in 2013 nor his contradictory statements between when he was interviewed by the plaintiff's counsel in April of 2013 and deposed in December of 2013 could have been in furtherance of a conspiracy of silence or harmed the plaintiffs because Michael had already been convicted for sexually abusing the Doe 1 children, and the plaintiffs had already hired counsel to pursue this action. We view this evidence quite differently because a purpose of the alleged conspiracy was not just to protect Michael, but also to cover up the church's alleged role in facilitating Michael's abuse. Certain statements made by UD1 when he was interviewed by the plaintiff's counsel are clearly adverse to the defense in this matter in terms of what the defendants knew and when. When UD1 was subsequently deposed, after meeting with the church's lawyers for 12 to 13 hours, he contradicted his earlier statements given in the interview. He explains this altered tact by criticizing the, quote, imprecise, vague, and leading questions, unquote, asked previously by the plaintiff's counsel. A jury could reasonably infer, however, that UD1 changed his story in furtherance of a purpose of the conspiracy to conceal the church's involvement, regardless of whether another purpose of the conspiracy to protect Michael could no longer be served. As John Doe 5 testified during his deposition, UD1, quote, always told him that he would not do anything to hurt the church, unquote. Similar to the conspiracy claim against the other defendants, there are numerous material issues of fact and disagreement as to the inferences to be drawn from those disputed facts. It is clear, however, that the circuit court improperly made determinations reserved to a jury and wrongfully assumed the veracity of statements made by defense witnesses as a precursor to its conclusion that, quote, there is no evidence that UD1 knew about Michael Jensen's abuse of the minor plaintiffs until after Michael Jensen was arrested. There is also no evidence that UD1's actions helped or assisted other defendants in breaching a duty that harmed plaintiffs, unquote. If a jury were to resolve the disputed evidence, make credibility determinations, and draw reasonable inferences, all in the plaintiff's favor, it could find that UD1 was part of a conspiracy and that his conduct furthered and promoted unlawful purposes designed to protect the Jensens and conceal the church's involvement, which resulted in intentional torts and the plaintiff's alleged harm. Accordingly, and for these reasons, we find the circuit court erred in granting UD1's motion for summary judgment, The Circuit Court also dismissed the plaintiff's request for punitive damages against UD1 in light of its summary judgment ruling. Because we reversed the award of the summary judgment in favor of UD1, we also reversed the Circuit Court's ruling on punitive damages. Conclusion. Based on the foregoing, we reversed the Circuit Court's December 4th, 2015 order granting summary judgment in favor of UD1 and dismissing the plaintiff's request for an award of punitive damages against him. We also reversed the particular in lumina rulings in the Circuit Court's December 30th, 2015 order that have been addressed herein. Finally, we reversed the Circuit Court's December 31st, 2015 order granting summary judgment in favor of the church defendants and Chris and Sandra Lee Jensen on the plaintiff's conspiracy claim. This action is remanded for further proceedings consistent with this opinion. Reversed and remanded. Well, so that was really intense. So there's a lot here. So what I'm going to do is I'm going to get together with America and we're going to summarize this whole case, and then we're going to tie it into the church suing their insurance providers. So I left the church in 2021. I don't know. It was a mixture. But this case happened this story broke in 2019. So this is new to me. So I should know about this, but I don't. I knew about the case in Arizona with Paul Adams, but this is new. So this is exciting. Hope you guys have a great day. I hope you guys find this interesting, and I'm excited. I'm interested to see how the church handles everything going forward. No.